shall not be infringed. These four words carry a weight that echoes through the corridors of history. These four words, enshrined in the Second Amendment of the United States Constitution, are not a suggestion, nor are they a mere formality. They are not a recommendation or a quaint notion from a bygone era. They are a declaration, a proclamation of a fundamental principle. They are an absolute and unequivocal command, a directive that stands the test of time. This command is a line drawn in the sand by our founding fathers, a line that signifies the boundary of governmental power, a line that protects a fundamental right, the right of the people to keep and bear arms. This right is not just a privilege, it is a cornerstone of our liberty. This right is not granted by government, it is inherent, a natural right that pre-exists any government. It is a right that belongs to every individual, regardless of their status or station. It is a natural right that pre-exists any government. It is a right that is as old as humanity itself, a right that is rooted in the very essence of our being. It is a right that protects all other rights. Without the right to keep and bear arms, all other rights are vulnerable, subject to the whims of those in power. The Second Amendment stands as a bulwark against tyranny, a safeguard of liberty, and a testament to the foresight of our nation's founders. It is a reminder that freedom is not free, that it must be defended and preserved. The Second Amendment is a testament to the foresight of our nation's founders, a reminder of the sacrifices made to secure our freedom. It is a call to vigilance, a call to stand firm in the defense of our rights. Informed gun owners across this country understand the gravity of the Second Amendment. They know the arguments laid out in the Federalist Papers. They recognize the historical context in which this right was enshrined. They understand that the Second Amendment is not about hunting or even self-defense in the narrowest sense. It is about the fundamental right of a free people to defend themselves against any and all threats to their liberty, be it from criminals or tyrannical governments. Tench Coxe, a founding father and a close confidant of James Madison, wrote that the power of the sword be put in the hands of the people. This statement cuts to the heart of the Second Amendment. It recognizes that a well-armed citizenry is the ultimate guarantor of liberty. When the people are disarmed, power naturally flows to the government. This is not a hypothetical argument. It is a historical reality that has played out time and again in nations around the world. Unfortunately, this fundamental right has come under relentless assault, not by foreign enemies, but by those within our own government who seem determined to chip away at the very foundation of our freedoms. We have seen countless attempts to restrict, regulate, and ultimately disarm law-abiding citizens. Even the Supreme Court, the very institution tasked with upholding the Constitution, has at times failed to fully grasp the true meaning and scope of the Second Amendment. Some justices seem more concerned with appeasing the anti-gun lobby than with upholding the original intent of the Constitution. The concept of stare decisis, the principle of upholding precedent, has been used to justify decisions that clearly contradict the plain language of the Constitution. But stare decisis is not a suicide pact. It should not bind us to flawed interpretations of the past, especially when those interpretations infringe upon our fundamental rights. We must remember that Supreme Court justices are not philosopher kings. They are appointed through a political process, and their interpretations of the Constitution are often influenced by their own personal biases and political leanings. The Second Amendment stands as an equalizer. It ensures that the power dynamic in this country does not tilt irrevocably in favor of the government. It reminds those in power that they govern with the consent of the governed, and that consent can be withdrawn. This is not a radical notion. It is the very essence of American exceptionalism. It is the belief that the individual is sovereign, that government derives its just powers from the consent of the governed, and that the right of the people to defend themselves against tyranny is absolute and inviolable. The 2008 Supreme Court decision in District of Columbia v. Heller was a landmark victory for gun rights advocates. This case fundamentally reshaped the landscape of Second Amendment jurisprudence, setting a precedent that continues to influence legal interpretations and public policy debates to this day. In Heller, the court affirmed that the Second Amendment protects an individual's right to possess a firearm, unconnected with service in a militia, and to use that arm for traditionally lawful purposes, such as self-defense within the home. This ruling underscored the importance of personal safety and the right to protect oneself and one's family, a principle deeply rooted in American history and tradition. However, the Heller decision also introduced the concept of arms in common use for lawful purposes. This phrase, while seemingly straightforward, carries significant implications. It suggests that the types of firearms protected under the Second Amendment are those that are commonly owned and used by law-abiding citizens for legitimate activities such as self-defense, hunting, and recreational shooting. This language, while seemingly innocuous, has the potential to be used to restrict the types of firearms that law-abiding citizens can own. By focusing on common use, courts and lawmakers may interpret this to mean that only certain types of firearms, those that are widely owned and recognized for lawful purposes, are protected. This interpretation could lead to debates and legal battles over what constitutes common use and which firearms fall under this category. The Heller decision, therefore, not only affirmed individual gun rights, but also opened the door to ongoing discussions and legal challenges regarding the scope and limits of the Second Amendment. The Founding Fathers understood that the price of liberty is eternal vigilance. They knew that the fight for freedom is never truly over, that each generation must be prepared to defend the rights that were won for them by those who came before. The Second Amendment is their gift to us, a tool to safeguard our liberty and to ensure that the sacrifices they made were not in vain. It is a reminder that the power ultimately resides in the hands of the people. We live in a time of unprecedented technological advancement. Every day, new innovations are introduced that change the way we live, work, and interact with the world around us. From the smartphones in our pockets to the artificial intelligence systems that are beginning to permeate various aspects of our lives, technology is evolving at a breakneck pace. New firearms technologies are emerging all the time. These advancements include everything from smart guns with fingerprint recognition to more efficient and powerful ammunition. The landscape of personal defense and law enforcement is continually being reshaped by these innovations. Some argue that these advancements render the Second Amendment obsolete. They claim that the Founding Fathers could not have anticipated the kinds of weapons we have today, and that the right to bear arms should be reconsidered in light of modern technology. This debate is often heated, with passionate arguments on both sides. But the principles enshrined in the Constitution are timeless. The document was crafted with the understanding that society would evolve and change. The founders designed it to be a living document, one that could adapt to new circumstances while maintaining its core values. They are not bound by the limitations of any particular technology. The essence of these principles transcends the tools and technologies of any given era. Whether we are talking about muskets or future firearm technologies, the fundamental right to self-defense remains unchanged. The right to keep and bear arms, just like the right to free speech or the right to freedom of religion, must be understood and applied in the context of our times. These rights are interconnected and form the bedrock of our society. They ensure that individuals have the means to protect themselves, express their opinions, and practice their beliefs freely. The founders could not have foreseen the specific technological advancements we enjoy today. They lived in a world vastly different from our own, yet they had the foresight to create a framework that could endure through the ages. Their vision was not limited to the 18th century, but extended far into the future. They understood that the human desire for liberty is eternal, and they crafted a constitution that would endure the test of time. This document has been a guiding light for over 2 centuries, adapting to new challenges while preserving the fundamental freedoms it enshrines. The Second Amendment is a testament to their wisdom and foresight, a beacon of freedom that continues to shine brightly in the 21st century. It serves as a reminder that while technology may change, the core values of liberty, self-defense, and personal responsibility remain constant. As we navigate the complexities of modern life, these timeless principles provide a steady foundation upon which we can build a just and free society. In conclusion, the Constitution does not give the government the power to regulate firearms. In fact, the Constitution strictly forbids any government regulation of firearms. No free man shall ever be debarred the use of arms. Thomas Jefferson in the first draft of the Virginia Constitution. The Constitution of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that it is their right and duty to be at all times armed. Thomas Jefferson, in a letter to John Cartwright in 1824. Thomas Jefferson also wrote, "On every occasion of constitutional interpretation, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, and instead of trying to force what meaning may be squeezed out of the text or invented against it, instead, let us conform to the probable one in which it was passed. Stay frosty, my friends, this fight is far from over. Keep your head down and your powder dry."